Now we're going to talk about steps in a lawsuit. Very broad-based, so there's a core understanding of what happens during the course of a lawsuit. First, before I get into the details of it, let me make a clear distinction. There's a significant difference between federal court and state court. The court structures in the United States has one global federal court, and all the federal courts deal with federal issues, and it's all the same rules for federal court. They have a standard rules of evidence, standard procedural rules that govern all federal courts. Now, whether a case is eligible to go to federal court is defined on what are called jurisdictional terms. Jurisdiction is this fancy term. All it means is what is the right house to go visit. It's the way I would think about it. You're not allowed in certain houses unless you have certain prerequisites. If you don't have these prerequisites, you can't go to this house, but there's another house that you're eligible for. And that's basically what jurisdiction is. So in federal court, the jurisdiction, you're allowed to go to that federal house of the court system automatically if it is a federal issue. What is a federal issue? Something where there's a constitutional violation or there's a specific statute that says you can bring this case in federal court. What I'm defining here on jurisdiction is weeks, if not months, within law school training. So I'm breaking it down to a minute and a half. There's much more to it, but I want to just give the broad understanding. So to get to the federal court system in the federal house, you have to have a federal issue, or there's another path to get to federal court. It's called diversity. Basically, it's allowing people the comfort that they won't be hometowned. And I'll define it simply as that if an individual from New York is going to sue an individual from Michigan, and the only place they can sue them is in the state of Michigan, they may be worried that if they go into Michigan and they are in the state court system where the state judge may have a relationship with the lawyers from Michigan and they're fearful of being hometowned, they then, because they're from two different states, that's what's called diversity, they're from two different states, and if their claim rises to a certain financial level, which is significant, then they are eligible to go to federal court and have a federal judge, which is not governed in any way. You have less concern of being hometowned. Of course, that's my nomenclature. Those are really my terms so you can understand it. No place in law I don't think you'll find in a case that says, go to federal court so you're not hometowned. But I think everybody understands what I mean by that. Let me just qualify one thing about diversity in federal court. In order to have diversity to go to federal court, that means one side is from New York, the other side is from Michigan. They have to have what's called complete diversity. So if the lawsuit where the people are from New York are suing the people from Michigan, but they are also suing somebody from New York, that's not complete diversity. So if you've seen what's called the caption of a lawsuit, which names the parties, the person bringing the lawsuit is called the plaintiff, versus, and then the defendants. If one of the defendants is from the same state, you do not have diversity because on each side of the V, you have parties from from the same state. There's no diversity. You're not eligible to go to federal court based on diversity. So leaving federal court aside, what about in state court? To start a state court lawsuit, it's governed by each individual state, but most states run the way that I'll just describe for you now. First and foremost, the time to start a lawsuit is called the statute of limitations. Statute is just a fancy name for another name for law. What does the law say as to when I can bring a lawsuit? And if you don't bring your lawsuit within the defined time frame, then you are forever barred. You're not allowed to bring that lawsuit. Basically, each state defines what the statute of limitations is, and this is a very complex area of the law, because not only does each state have a different statute of limitations, each state, for every type of lawsuit, has a different statute of limitations, a different time frame that you have to bring that lawsuit by. So, for example, in New York State, to bring a personal injury case, a standard personal injury case, it's 3 years from the date of the injury-producing event. It's very broad. There are exceptions. And the day that the time frame starts to run is what's called the day the lawsuit accrues, when all the facts and circumstances were known to the person who now has the clock ticking on when they need to bring that lawsuit. So very broadly, if a personal injury case is 3 years, a subsection of personal injury cases are personal injury cases against doctors or medical providers, hospitals. Those are called medical malpractice cases. They're still personal injury cases, but there it's not 3 years in the state of New York, it's 2.5 years. And it's 2.5 years from the last date of treatment of that medical provider. So, for example, if a medical provider fails to diagnose cancer, and they failed to diagnose cancer in January of a particular year, and you continue treating with that physician, and now we're in October, and now you decide you no longer want to treat with that physician because that's when you've learned that you actually have cancer and it should have been caught in January, your cause of action, your statute of limitations, starts to run in October when you stopped treating with that individual, even though the actual malpractice happened in January. That's just one simple caveat or example of how complex it could be. And those are just on injury cases. One other component there, it depends on who you're suing. If you're suing an individual or a corporation, it may be one time frame, but if you're suing a municipality, a government official, a town, a police officer, it may be a different time frame for the exact same event. So if it is a car crash, and it's a car crash between two individuals, it's 3 years in the state of New York. But if it's a car crash with a state trooper, there may be a 90-day filing, or a city police officer may have a 45-day. Each municipality may have different filings. This is a very detailed area of the law, which is where you should either research it yourself or go to a experienced lawyer who would know what all the different statutes are. And lastly, with respect to statute of limitations, it's by type of case. So one more example is a contract claim. If you have a contract claim with an individual in the state of New York and you're claiming breach of contract, that's a 6-year statute of limitations. A fraud claim, if you're claiming fraud, that may be 1 year. So as you can see, that's just in the state of New York. In New Jersey, the statute of limitations for an injury case is 2 years, where in New York it's 3 years. In the state of Maine, it's 6 years, but the wrongful death may be much shorter. So I'm simply throwing out all of these states and dates to caution you that the smartest thing to do is get a consultation with a lawyer who generally doesn't charge in this area of law, injury law, to simply find out what your statute of limitations is. But once you know the statute of limitations, and I'm going to use 3 years for my example, you have from the date of the event 3 years to start the lawsuit. So how does a lawsuit start? I hate to add another layer of complexity, but every state defines the actual commencement of a lawsuit in their own way. Some states, you simply have to file it with the court and serve it on the court. And with electronic filings, that's happening more and more. Many other states, however, require actual notice to the person that's being sued. So just because a paper that starts a lawsuit, it's called a summons, starts that lawsuit, is drafted and filed, that may not start the lawsuit because the individual doesn't know about it. So there's what's called personal service, physically handing a summons, and then a summons says you are being sued, and then the next document is a complaint. What is the complaint? This is what I'm suing you for. This is what the allegations are, that you are a driver of a car or an owner of a car, and you caused a crash and caused injuries as a result. It sets out in a very, very broad terms what the allegations are for the lawsuit. Why are you suing whoever is being sued? The person who receives it must have adequate notice of why they're being sued. And each state defines what adequate notice is satisfied by, but generally personal service certainly satisfies actual notice, and the documentation the complaint is very broadly drafted. Broad allegations. It could be as broad as you were the driver of a car, we allege that you were the owner of the car, that vehicle came into contact with a pedestrian crossing a street and you caused serious injuries. And this happened on, and you give the day that it happened. Very, very broad. That is how a lawsuit starts. But the next step of the lawsuit after a complaint, that's when each state has automatic triggers of time when things must happen. So after a complaint is physically handed to a defendant, the party that brings the complaint is called the plaintiff. When the plaintiff who brings the complaint against a defendant who now has to defend the case, the defendant has a defined period of time to answer the complaint. And when they answer the complaint, they generally answer each paragraph individually. That's why when a lawyer serves a complaint on a defendant, there may be 20 paragraphs. Paragraph 1, you were the driver of a car on January 15th. Paragraph 2, as the driver of a car, you caused that car to strike a pedestrian. Paragraph 3, you were the owner of a car. Paragraph 4, as the owner of the car, you allowed the driver to strike a pedestrian. You get the idea that it's broken down into sub-parts, because when that complaint is answered, the answering party, the defendant, has 3 choices on how to answer it. Each subparagraph is they either admit what's contained in the allegation, that you were the driver of the car, I admit. They can deny, no, I was not the driver of a car, and they literally write the word deny. Or if it's an allegation that they're not too sure about, they can DKI, deny knowledge or information, such that they can neither admit or deny. They just don't know. So they could say, you caused, as the driver of the vehicle, you caused it to come into contact with Jane Doe. Well, if they don't know who Jane Doe is or anything about it, they can deny knowledge or information with respect to it. So those are the three types of responses to a complaint and allegations within a complaint. There's a term in law which is called issue is joined. And what happens is the complaint sets forth the issues, and the answer is either admit, deny, or deny knowledge or information. Surely if everything is admitted, then it's easy. Then there's nothing that has to be proven other than the extent of the damages that are caused. But that's rarely the case. The issue is joined on every allegation where there's been a denial or denied knowledge or information with respect to the allegations in the complaint. And that's what the lawsuit then becomes about. Because you have one party that is making an allegation and another party that's denying that allegation, and that is what makes the fight, frankly. That's the lawsuit. So that's the initial steps of the lawsuit. The commencement by filing and serving a summons and complaint, and then the answer determines which issues will the lawsuit be about. The next phase of the litigation, the lawsuit, is broadly termed discovery. Many people, when they hear about a trial, they think that a trial is surprises. Anybody or any lawyer who actively litigates cases realizes that there are no surprises at trial, that the length of the litigation, which I'm going to explain all the steps, we actually know everything about what the other side claims and how they're going to defend the case. There are no secrets at trial. What happens at trial is everybody puts forth their argument and how those facts should be received and perceived, but there's no secrets. There are no surprises at trial. This is not like television where there are these surprise witnesses that come in. You're not allowed to do that. There's no trial by ambush. So what are the steps where we learn about everything about the other side and the other claims? So the first phase of the litigation after it's been started is broadly called discovery. Discovery means we discover everything about the other side. And discovery comes in three different types. First, it's paper discovery. The lawyers write requests to one another and say, now you've denied all of the information with respect to the allegation that the defendant was the driver of the vehicle. If there's any paper that can support that, provide that information, they're listed on the police report, and there's a request basically to exchange all paper information. Generally what happens is the parties must exchange any witness statements that they have to an event, contracts that may cover the event depending on the type of case, any photographs, any documentation that is most importantly relevant to the case. And the lawyers have an obligation to provide that to the other side. In addition to making the requests of the other side of the information you want, the attorney is always receiving demands from the party on the other side that's of the litigation, demands of them to provide the information. So there's papers going back and forth. We need all of the medical records, and then the defendant insurance company lawyer will say, provide all of the medical records, or provide an authorization where the injured person gives us the authority to go get all the medical records ourselves. Give us all of the photographs of the damage to the vehicles. Give us the photographs of the property where you claim that the injury occurred where the person fell. That would come from the insurance company. The lawyer for the injured party would give us all of the contracts that you had in place for the landscapers required to maintain the property. Give us all the photos that you have of the property as it existed on that day. With the advent of all of the surveillance cameras, provide all of the surveillance information that you may have. A party is obligated to preserve all of that. They can't take a video that they have and dispose of it. Because in law, if somebody has something that's relevant to a litigation and they dispose of it, it's called spoliation. That means they've disposed of something that's relevant to the case. There's a remedy, there are consequences, and the remedy to the party that didn't get the benefit of seeing that which was disposed, the remedy can go anywhere from the cost transferred to recreate what was disposed, all the way up to the punishment that the person who disposed of it automatically loses. They lost the case. A judge can rule, because you disposed of evidence that was so critical to the case, you lose, because you've so injured the process of the litigation that we will never be able to get to the truth. That's the most drastic remedy, and it certainly happens at times. So many times people say, well, aren't they just going to throw it out? Lawyers can't control what the other side's client is going to do, but they can seek the appropriate remedy and seek the consequences if they don't honor what they're supposed to do, and is provide that information. But this initial phase of discovery, again, is just paper, back and forth. Ultimately, a judge is asked to participate because, as I've outlined for you, most times judges are not assigned until the lawyers don't cooperate with one another anymore. So at first, there's no lawyer assigned to a case in most states. But once a lawyer fails to cooperate, and each state defines what lack of cooperation really means. So for example, in New York State, if a deposition, and I have another video that fully defines depositions, but if a deposition where the parties are asked to give testimony prior to trial is scheduled and it's adjourned or canceled 2 times, that then becomes a basis to write a letter to the court and say, we now need a judge. A judge needs to get involved because the lawyers aren't cooperating. There are other scenarios that qualify when you can get a judge involved. But during the paper discovery, in theory, everybody cooperates and provides all of the necessary information. And after all the paper discovery is complete, the next step is the deposition. Oftentimes, the paper discovery, there is a dispute and a judge is involved, and a judge will perform or have a conference, rule on a conference, and it's generally called a preliminary conference. The reason why it's called a preliminary conference is because it's the first conference before the judge, and the judge really knows very little about the case. The judge simply asks the lawyers, tell me what this case is about, and what's the dispute? Why are you here? And the lawyers will give the basic facts of the case and then get down to it and say, and judge, we have asked to have a deposition of the other party 2 times. We've scheduled it, and it was canceled 2 times. We're asking you to order that the other side come to the deposition. Once that order is in place, that's when things generally start to move. Not always, but generally start to move, because to violate a judge's order that says you must produce a witness and that person must testify, the same remedy is available that is available for spoliation, which is we could say, Judge, you ordered that they show up on March 15th and they canceled again. We believe the remedy should be we win the lawsuit. It's a harsh remedy. Most judges, in fact, all judges, will give the parties another opportunity to comply with the judge's orders. But the judge doesn't look kindly on lawyers and the parties who ignore the judge's orders. So it is a word for the wise to try to comply with judge's orders. So the first phase is commencement of the lawsuit. The second phase is discovery. Within discovery, the first part of discovery is the paper discovery, and now we're up to the deposition. So a deposition, very briefly, is where the lawyers and the parties go to an agreed upon conference room, no judges involved, where they sit and ask one another in an orderly way questions related to the event and the basis of the lawsuit and the basis of how the lawsuit is being defended. All questions and all answers are transcribed either on first initially videotape, or there's a court reporter there who with a little machine takes down what everybody says. There too is state specific. Sometimes the deposition is videotaped. Other times it's simply just oral questions and answers. After the deposition is complete, if it's an injury case, the next phase is the defendant who is being accused of causing the injury is entitled to hire a doctor to perform a physical exam so that they're able to defend the allegations related to the injury. I have a separate video that fully outlines and defines what some call an IME, independent medical exam, but I'll clue you in now. There's nothing independent about that medical exam. I call them a DME, which is a defense medical exam. And make no mistake about it, the doctor knows who hired them, and the sole purpose is to defend the claims. So I encourage you to watch the other video with respect to how to conduct yourself at a defense medical exam. So the medical exam is performed, and at that point in time, the parties know everything they should know about one another. That is, the lawsuit, the allegations in the lawsuit, the paper that went back and forth of the photographs that support the respective claims. The lawyers provide legal documents that fully articulate what the claims are, because in the complaint it's very broad. It'll say, and the pedestrian was seriously injured. Well, as part of the paper discovery, the lawyer for the insurance company will, in substance, say, well, you claim they're seriously injured, but what specific injuries are you claiming from this particular crash? The lawyer who represents the injured person will give details of what the claimed injuries are and all of the medical supporting documentation. Now, after that, the deposition. After the deposition, the physical exam. And the next step is to let the court know, the judge know, that everything is done. We are now fully complied with all of your court orders. We've exchanged all of the information. We have interviewed at a deposition the other side, and we've had our medical exams, and we know everything we need to know about one another, so let's have a trial date. Most judges literally just look at their calendar and they pick the next available trial date. Again, it's depending on each state, but some judges work faster than others. You can have in the same courthouse the same type of case go before one judge and they will give you a trial date in 6 weeks. You can go the exact same scenario, the court right next door, the courtroom right next door, different judge, say, come back in 18 months. There's nothing you can do. But the lawsuit is complete from the standpoint that the lawyer doesn't have to do anything until a few weeks before trial because there's no more discovery. Discovery is closed. Once discovery is closed and all the paper has been exchanged, you're generally not allowed to seek more discovery because you are certifying, the lawyer for the injured party certifies that they know everything they need to know about one another. So basically, and I'll be blunt, the file, the case, sits on the shelf, not entirely, until 3-4 weeks before the trial date, because there's no activity that happens in between. I'm talking in the actual litigation. And then 3 or 4 weeks before the actual trial date, the lawyer will start to connect with the various witnesses, start scheduling the process at trial, and really engage in planning out who the first witness will be. And then the lawyer will prepare the client during that 3-week period of time, provide the client their deposition transcript, which is really just the questions and answers that were performed at the deposition. They're typed up so you can read them. And then the trial commences. And the trial, it starts with jury selection. Each state performs their own jury selection differently. Some states, the judge picks the jury. Some states, the judge isn't even involved in the jury selection process. The lawyers simply go into a room and the commissioner of jurors brings in 60 people, and the first 6 or 12 people are interviewed, and the lawyers are able to do it without a judge involved. But ultimately, a jury that is hopefully not biased with respect to the decisions they're asked to decide in that particular case. They're what's called empaneled, they're sworn in. Then the plaintiff who brings the lawsuit, he has what is called the burden of proof. He has the burden of putting forth enough evidence to satisfy reasonable people to say what they claim has been said is true. And after the plaintiff puts forth all of their evidence, whether it's through testimony or documents, they then say to the judge, we rest. That's the fancy way of saying we're done. We've put forth everything we believe to make out the case. At that point in time, the burden shifts to the defendant. If the defendant thinks that the plaintiff, the person who brought the case, has not satisfied their burden, they may say, we have no proof. They had the obligation to prove the case. We don't think they proved it, so we're not doing anything. That doesn't happen too often, but they can do that. More often, the defense lawyer will put on a defense, and they'll call the doctor who was hired to examine the injured person, and they may have other types of proof. If they deny how it happened, they'll certainly put on proof that supports their position that it happened in wholly differently than the way the injured party claims it happened. But then after all the proof is in, the lawyers have an opportunity to share with the jury what they feel is the fair interpretation of the evidence and give final argument, and then the case goes to the jury. That's the process of a lawsuit and litigation, but here's the most important thing that you should not overlook. Underneath all of that process, there are negotiations that are going on. The insurance company and the lawyer for the injured party are talking at different times on can the case be resolved. because litigation is very expensive. Trials are very expensive, both sides, but define what their risk is related to the underlying case. I have a separate video as to how to value a case. I encourage you to watch that. The negotiations happen at different phases. Now, there's nothing that limits when negotiations can happen. Negotiations can occur before a lawsuit is started, right on through while a jury is deliberating. A case can settle at any time. And there are also two alternative devices to try to resolve a case. That is, if a plaintiff, an injured party, and their lawyer can't come to an agreed upon settlement amount with the insurance company directly, they may choose an alternative dispute resolution. Rather than go through a trial, they may choose an arbitration. I caution you that an arbitration is binding. Once a party enters an arbitration agreement, they are agreeing to allow an arbitrator, an individual who is agreed upon by the parties, rather than a jury of their peers, to make the final decision on whether they should recover, and if they should recover, what they should recover. That's binding arbitration. It takes it out of the case, out of the court system, and puts it into an alternative dispute resolution system. Most arbitrators are either experienced lawyers or judges. I'd suggest to you that a binding arbitration is only appropriate if there is a limitation on the amount of insurance that's available, and it just doesn't make sense to go forward with a trial. Personally, I much prefer a jury from the community who have a vested interest in the outcome of the case to protect themselves than an arbitrator, because an arbitrator's motive, and I hate to use the phrase, but it comes to mind, split the baby. The arbitrator doesn't want to make one side angry because they are concerned about their future business, and they don't want to make the other side too happy because they're worried about their future business. So it's much like kissing your sister going to an arbitration. There's nothing good about it. I only suggest arbitrations if there is a limitation on how much insurance is available, and it's an economic way to resolve a dispute. The alternative to arbitration is mediation. Now, the difference between arbitration and mediation is a mediator's role and purpose is not to decide the case. The mediator has no authority or control over the case, and it's not binding. So a mediation is where the parties agree to again, generally use an experienced lawyer or a retired judge, and each side communicates why they believe they're right, and then they split into separate rooms, and the mediator generally goes from one room to the other room and trying to narrow down and bring people to a resolution where both sides are happy with it. Mediations happen quite frequently, but bear in mind, a mediator's role is not to get the most of an award for an injured individual. The mediator's role and purpose is just to try to find a resolution. They really don't care what that final number is. They're happy when a case settles. So I would caution you, when a mediator is making suggestions on values, the ulterior motive that a mediator often has is not to get the most for an injured person. Their motive is simply to get a resolution done. So those are the broad steps of a lawsuit and some ulterior ways to get cases resolved.